24 today, which is reporting that Chief Justice Raymond Zondo will soon lead a process that could see suspended Judge Nkola Motata be impeached. The publication says the Judicial Service Commission will not challenge a Supreme Court of Appeal ruling that Motata should face a vote. It comes after he was found guilty of drunk driving for crashing his luxury vehicle into a Handringham Manor home 15 years ago. For more on this, let's speak to UCT senior researcher Chris Oxtoby. Chris, a very good evening to you. Welcome to the program. So, put in context for a moment the significance of this next step.
I mean, the first obvious point of its significance is that it's the first time that a potential impeachment of a judge has actually got this far, that it is actually going to Parliament and going to be considered by Parliament. The only other equivalent case like this we've had is obviously the process against Judge President Klope. That has also been referred to Parliament, but is being challenged in the courts. So, as I say, we've never got this far along in the process. Parliament will now have to consider the record of the complaint against Judge Motata, and it will then have to decide whether or not to adopt a resolution for him to be removed from office. That needs a 2/3 majority in Parliament. And if that is passed, this would actually be the first time in South African history that a judge has been impeached, removed from office under this process.
And is that, Chris, exclusively because no other judge has committed a more serious offence, or because this avenue has not been explored in the past, even when there have been worse offences, shall we say, committed by sitting judges?
It's a good question. It's a combination of the two. I mean, there's, as we know, there are other high-profile examples of serious misconduct by some judges, which may still get to this point as well. The particular process under which Judge Motata's the complaint against him was dealt with was a fairly new one and was subject to a lot of legal challenges during the process. And that contributed to it taking so long as it has. And the Supreme Court of Appeal, in its judgment, pointed out that it's been 16 years since the initial incident happened. That's partly been because of failings on the part of the JSC to deal with the matter more quickly, and also partly because of the number of court challenges to this process that have been going on. It's hoped that now that the dam wall has broken, if you like, and that we've actually got this far in the process, future cases are going to move more quickly, because this clearly took far too long, and it is important for the credibility of the judiciary that cases move more quickly. But as you point out, it's not completely unique. It's not the only such serious complaint against a judge, and we may see some others like it coming through the system in the near future.
Is it appropriate to use as a sanction for Motata's offence? Yes, he drove drunk, crashed into a wall, also was found to have lied when he said that the person who recorded the whole incident had called him the K-word or used racist language. Does the sanction fit the crime, if you will?
So the view that the Judicial Conduct Tribunal, which presided into the inquiry into this complaint, took was that yes, it did, and the JSC initially split in its view of whether or not to accept that finding. The Supreme Court of Appeal has endorsed the original Conduct Tribunal finding. So there are two very weighty findings that say, yes, it does. I think the fact that, as you say, there were two elements to the finding of misconduct. The one was this allegation that racist language was used by the complainant, which was found not to be supported. And the second was a complaint that the judge had allowed a defence to be put forward that he knew to be untrue. Obviously, both of these are very serious findings that speak very much to the integrity of a judicial officer who one expects to uphold the highest of ethical standards.
So those are standing findings, right? Because those are confirmed.
Yes.
That is the situation. Yes. That is the set of facts that we're working with. I'm curious then about how intense a process the impeachment hearings will be, and what they will then seek to find, and ultimately how they'll come to the conclusion, if that's where it'll go, that he should be impeached.
And this is what we wait with bated breath to see, because we've never actually reached this stage of the process yet. So Parliament has not yet been faced with a decision on whether or not to call for his removal from office. I mean, just to highlight again that the Constitution does require a 2/3 majority for this resolution. And if this sounds like it's a very convoluted and difficult process to remove a judge, there are good reasons for that. We don't want to make it too easy for a judge to be removed from office, because obviously that would pose a risk to their independence and their ability to make decisions without being under pressure. So the short answer is that Parliament has to vote on a resolution, and there has to be a 2/3 majority calling for his removal. If the vote does not get that 2/3 majority, then he is not removed from office. He's not impeached. If the vote does get the 2/3 majority, then that's it. He's out. The president is then obliged to execute a formality of removing him from office. Exactly what the minutiae of that process is going to look like in Parliament, frankly, I'm not sure yet, because we have no precedent for it. But Parliament is required to take that next step and to vote on a resolution. Whether or not we get the 2/3 majority, we'll have to wait and see.
Chris Oxtoby, good to speak to you. Thank you so much. UCT senior researcher talking to us on News at Prime.